Good morning to all of you. I hope I'm audible and visible. So today we are going to discuss MP Civil Judge 2016 question paper. Now let me tell you, before 2017 onwards, from the question paper of 2016 onwards, जो आपके पर्टिकुलर क्वेश्चंस आते थे एमपी सिविल जज के एग्जाम में वो 100 क्वेश्चंस आते थे. 2017 से 150 क्वेश्चंस आने शुरू हुए. उसके पहले आपके 100 क्वेश्चंस आते थे, जिसमें से 75 क्वेश्चंस लॉ के होते थे और रिमेनिंग क्वेश्चन जो 25 क्वेश्चंस होते थे वो जीके, इंग्लिश और कंप्यूटर से होते थे. तो आज हम लोग डिस्कशन करने वाले हैं एमपी सिविल जज 2016 के क्वेश्चन पेपर का, जिसमें हम लोग डिस्कस करने वाले हैं सम ऑफ द क्वेश्चंस फ्रॉम कॉन्स्टिट्यूशन, सम ऑफ द क्वेश्चंस फ्रॉम सीपीसी, सम ऑफ द क्वेश्चंस फ्रॉम कॉन्ट्रैक्ट एक्ट एंड सम अदर क्वेश्चंस फ्रॉम आवर कॉन्स्टिट्यूशन. राइट, तो चलिए आज के डिस्कशन को हम लोग शुरू करते हैं. अगर अभी तक आप लोगों ने हमारे चैनल को सब्सक्राइब नहीं किया है तो प्लीज़ जाके हमारे चैनल को सब्सक्राइब कर दीजिए एंड डोंट फॉरगेट टू प्रेस द बेल आइकन सो दैट व्हेन एवर मी और एनी ऑफ द फैकल्टीज आर कमिंग लाइव तो आपको नोटिफिकेशन मिल जाए. एंड एमपी सिविल जज प्रीलिम्स के क्रैश कोर्स की लिंक इज़ इन द डिस्क्रिप्शन, तो एक बार उसे भी चेक कीजिए. हमारे 10+ मॉक्स डेफिनेटली आपको हेल्प करेंगे टू इंक्रीज योर स्कोर. हमारे रिकॉर्डेड वीडियो लेक्चर्स भी आपको बहुत हेल्प करेंगे टू डेवलप योर कंसेप्ट. सो लेट्स स्टार्ट टुडेज डिस्कशन. एज आई हैव स्टेटेड अर्लियर, ये है आपके एमपी सिविल जज प्रीलिम्स 2016 का क्वेश्चन पेपर. सो क्वेश्चन नंबर 1 इज, इन विच केस amendment in the constitution shall also be required to be ratified by the legislature of not less than one half of the state to that effect, where such an amendment in respect of option 1, option A, there are certain codes they have given. So the first code is article 54, 55, 73, 162 and 241. Second code is any of the list in the 7th schedule. Option C, representation of state in the parliament. Option D, provision regarding part 12 of chapter 1. Your options are option 1 only A and B, option 2 A, B and C, option 3 only C and D, and option 4 B, C and D. I am repeating the first question again. In which case amendment in the constitution shall also be required to be ratified by the legislature of not less than one half of the state to that effect, where such an amendment in respect of Code 1, Code A, that is Code A, Article 54, 55, 73, 162 or Article 271. Code 2, any of the list of the 7th schedule. Code 3, representation of states in the parliament. And Code D, that is provision relating to part 12 of chapter 1. Right, your options are only A and B, second option A, B and C, option 3 only C and D, and option 4 B, C and D. What should be the correct answer? Yes, just let me know quickly. Good morning Ankita, good morning to all of you. Now just let me know what should be the correct answer of question number 1. Hanji, you can read the question. I know the question is bit lengthy, but before answering it try to read the question properly and then only answer it. What should be the correct answer? So its correct answer will be your option 2, that is A, B and C. Right, chaliye next question. Question number 2, which among the following is not a fundamental right? Which among the following is not a fundamental right? So option A, right to equality, option B, right to freedom of religion, option C, right to constitutional remedies, option D, equal justice and free legal aid. Which of the following is not a fundamental right? Right to equality, right to freedom of religion, right to constitutional remedies, and right to equal justice and free legal aid. Option 1 A, B and C, option 2 only A, option 3 only D, option 4 only B. Yes, Vinny ji, first ka second is the correct answer. Now question number 2. What should be the correct answer of question number 2? Which of the following is not a fundamental right? Right to equality, right to freedom of religion, right to constitutional remedies, equal justice and free legal aid. 1. A, B and C. Option 2 only A. Option 3 only D. Option 4 only B. So its correct answer is only D, because that is option 3, because equal justice and free legal aid, this particular thing is not a fundamental right. It is defined under directive principles of the state policy under Article 39A of Indian Constitution. Next question, question number 3, that is, in the 6th schedule of Indian Constitution, provision with regard to administration of tribal areas of some states have been made. Which one of the following state is not included therein? Option 1 Meghalaya, option 2 Mizoram, option 3 Tripura and option 4 Manipur. In the 6th schedule of Indian Constitution, provision regarding administration of tribal areas of some states have been made. Which of the following state is not included therein? Option 1 Meghalaya, option 2 Mizoram, option 3 Tripura and option 4 Manipur. What should be the correct answer? Yes, Vinny ji, 2 ka 3 is the correct answer. That is your free legal aid and equal justice. These things are inculcated in the directive principles of the state policy, right? So question 3, its correct answer will be your option 4, that is Manipur, right? So Manipur is not included in the 6th schedule. Next question, question number 4. Article 17 of Indian Constitution deals with option 1 education, option 2 health, option 3 abolition of untouchability, option 4 food guarantee, right? Article 17 of Indian Constitution deals with education, health, abolition of untouchability and food guarantee. What should be the correct answer? Yes, Article 17 of Indian Constitution deals with health, education, abolition of untouchability and food guarantee. What should be the correct answer? Question number 4, its correct answer will be your option 3, that is abolition of untouchability. Remember that article 14 to 18, they are the part of, particularly they are the part of right to equality. So abolition of untouchability is defined under article 70. Yes, Ankita ji, Vinny ji, 3 ka 4 is the correct answer. Yes. Now next question. Now question number 5, criminal procedure code, 3 ka 4. Yes, Sudhanshu ji, Vinny ji, both of you are correct. Question number 5, criminal procedure code is subject of which list of Constitution of India? Criminal procedure code is subject of which list of Constitution of India? Yes, Sudhanshu ji, 4 ka 3 is the correct answer. Now option 1 central list, option 2 state list, option 3 concurrent list and option 4 residual list, right? So criminal procedure code is subject to which list of Constitution of India? Central list, state list, concurrent list and residual list. G. Question number 5, its correct answer will be your option 3, that is concurrent list. So criminal procedure code is a part of concurrent list, right? Shall next question, question number 6. Under civil procedure code, a court may not issue commission. Now 6th question, if you can see here 6th question is from your CPC, right? So under civil procedure code, a court may not issue commission for option 1 elucidating any matter in dispute, option 2 for ascertaining the market value of property, option 3 for ascertaining the amount of mesne profit or damage. Option 4, for framing of issues. Under Civil Procedure Code, a court may not issue commission for. Under Civil Procedure Code, the court may not issue commission for. Option 1, for elucidating the matter, any matter in dispute. Option 2, for ascertaining the market value of property. Option 3, for ascertaining the amount of any mesne profit or damage. Option 4, for framing of issues. So what should be the correct answer? Question number 6. Now, if you have read order 26 and if you have read section 75 to 78, you will be knowing it that the court may issue commission for elucidating the matter in dispute, for ascertaining the market value of property, for ascertaining the amount of any mesne profit or damage. Okay. Even further, the court may issue commission for local investigation, right, for sale, to adjust account. So its correct answer should be, sixth ka correct answer should be option 4, because here they are asking the court may not issue commission. So its correct answer should be your option 4, for framing of issues. Yes, question number 5 के साथ all of you are correct. सुधांशु जी, अंकिता जी, विनी जी, all of you are correct, right? Next question, question number 7. Under which provision the following orders of CPC provisions regarding a suit by indigent person has been given? Under which of the following order of CPC provision regarding a suit by indigent person is given? ठीक है. Option 1 order 32A, option 2 order 33, option 3 order 32, and option 4 order 34. What should be the correct answer? Now, order 32A is talking about suit relating to concerning to family members. Order 32 is talking about suit by or against a minor. So what should be the correct answer? Its correct answer should be your option 2, that is stating your order 33. So order 33 is stating suit by an indigent person. So 7th का correct answer will be your option 2. Yes, question number 6 के लिए all of you are correct. सुधांशु जी, अंकिता जी, विनी जी, 6 का 4 is the correct answer. Next question, question number 8. Under order 43 of CPC, against which order an appeal shall not lie? Under order 43 of CPC, under order 43 of Code of Civil Procedure, against which order an appeal shall not lie? First, an order to set aside or refusing to set aside a sale. Option 2, an order rejecting an application for permission to sue as an indigent person. Option 3, an order on an objection to draft of a document. Option 4, when the subordinate court has exercised its jurisdiction illegally or with material irregularity. What should be the correct answer? Question number 8. Saksham Sharma, good morning Saksham ji. चलिए, so under order 43 of Code of Civil Procedure, against which order an appeal shall not lie? First, an order to set aside or refusing to set aside a sale. Option 2, an order rejecting an application for permission to sue as an indigent person. Option 3, or an order on an objection to the draft of a document. And option 4, that is when subordinate court has exercised its jurisdiction illegally or with material irregularity. Yes, question number 7 के लिए all of you are correct. विनी जी, अंकिता जी, Saksham ji, all of you are correct. Its correct answer should be 7th का correct answer should be 2, right? Question number 8, its correct answer should be your option 4. ठीक है. So under order 43 of CPC, ठीक है, no appeal shall lie against the order, ठीक है, where the subordinate court has exercised its jurisdiction illegally or with material irregularity, right? Next question, question number 9. Which provision order of CPC deals with summons and attendance of witness? Which provision order of CPC deals with summons and attendance of witness. Order 5 of CPC, order 10 of CPC, order 16 of CPC and order 21 of CPC. अभी यहाँ पे देखिए क्वेश्चन नंबर 9 में they have played a mind game with us, right? They have simply put the question relating to summon. So whenever we hear the word summon, we simply get the impression कि भाई इसका तो correct answer always and always its correct answer should be your order 5, but it is not necessary. If you people would have followed up summons and attendance of witness, so this is given under your order 16. So its correct answer should be your option 3, that is order 16 of CPC, right? Yes, Ankita ji, you are correct. 8 का 4 is the correct answer. Vinny ji, 8 का 3 नहीं होगा, its correct answer should be 4, right? चलिए next question, question number 10, that is which provision order of CPC deals with production, impounding and returning of document. So which provision of CPC deals with production, impounding and returning of document? Yes, Saksham Gupta ji, 8 ka 4 is the correct answer. Which provision order of CPC deals with production, impounding and returning of document? Option 1, order 13 of CPC. Option 2, order 5 of CPC. Option 3, order 17 of CPC. And order 4, order 24 of CPC. What should be the correct answer? Yes, question number 10. What should be the correct answer? Order 13, order 5, order 17, order 24. So its correct answer should be question number 10 ka order 13 of CPC. So order 13 of CPC is talking about production, impounding and returning of document. Yes, Vinny ji, 9 ka 3 is the correct answer. So question number 10, which provision of CPC deals with production, impounding and returning of document? Its correct answer is your option 1, that is order 13 of CPC. Next, under Code of Civil Procedure, a litigant having a grievance of civil nature has a right to institute a suit if cognizance is option 1, not expressly barred, option 2, not impliedly barred, option 3, expressly and impliedly barred, option 4, none of these or none of the above. So under Code of Civil Procedure, a litigant having a grievance of civil nature has a right to institute a suit if the cognizance is not expressly barred, option 2, impliedly barred, option 3, expressly and impliedly barred, and option 4, none of these. Now question number 10. Yes, Vinny ji, 10 का 1 is the correct answer. Ankita ji, 10 का 3 नहीं होगा, 10 का 1 होगा, right? Question number Saksham Pathak ji, Saksham Sharma ji, 9th का 3 is the correct answer. Yes. Now question number 11. In this particular question, MP High Court played a mind game. So if you people are able to understand that mind game, you will be in the position to give the correct answer, right? So question number 11, its correct answer is your option 1, that is not expressly barred, because you have to understand, some of you might click on option 3, but option 3 will not be the correct answer because here they haven't used the word not expressly and impliedly barred. If they would have given not expressly and impliedly barred, then we would have gone with option 3, right? But they have stated expressly and impliedly barred, that is completely against of whatever is stated over there in section 9 of CPC. So its correct answer should be your option A. Question number 12. Under Civil Procedure Code, defendant can ask for temporary injunction against the plaintiff if option 1, plaintiff threatens the defendant to dispossess him from the suit property, option 2, the plaintiff threatens to dispose of the property with a view to defrauding his creditor, option 3, if the property in dispute in a suit is in danger of being wasted, damaged or alienated by the plaintiff. Option 4, if the defendant threatens the plaintiff to dispose of the property. Right? Now, so what should be the correct answer of question number 12? Please read question number 12 bit carefully because it's slightly lengthy and technical as well. Then only you will be in the position to give the correct answer of question number 12. What should be the correct answer? Hanji. Under CPC, defendant can ask for temporary injunction against the plaintiff if the plaintiff threatens to dispossess him from the suit property. Plaintiff threatens to dispose of the property with a view to defrauding his creditor. Option 3, if the property in dispute in a suit is in danger of being wasted, damaged or alienated by the plaintiff. Option 4, if the defendant threatens the plaintiff to dispose of the property. Right? So here firstly you have to understand that who is asking for temporary injunction. So defendant is asking for temporary injunction. So the defendant can ask for temporary injunction in the case of option 3. But in other cases, who is going to ask for injunction? The plaintiff is going to ask for injunction. So question number 12, its correct answer should be option 3. Yes, Vinny ji, you are correct. Question number 12 ka 3 is the correct answer. Question number 11 ka 1 is the correct answer. Vinny and Saksham, both of you are correct. Now, under CPC 1908, on the death of either party to the suit between the conclusion of hearing and pronouncing of the judgment, the suit, option 1, shall abate. Option 2, shall not abate. Option 3, may abate with the permission of court. Option 4, may abate with the consent of the parties. So, on the death of either parties to the suit between the conclusion of hearing and pronouncing of judgment. So here what they are saying, that conclusion of trial has taken place, but the judgment hasn't pronounced by the court, and any of the party dies, any of the party to the suit dies, then in that case what will happen? Suit shall abate, shall not abate, may abate with the permission of court, and may abate with the consent of other party. So its correct answer will be your option B, that the suit shall not abate. Next question. Under Civil Procedure Code, who is not exempted from personal appearance in the civil court? Option 1, Vice President of India. Option 2, Minister of Union and State. Option 3, Judges of Supreme Court and High Court. And option 4, Chairman of Union Public Service Commission. What should be the correct answer? Question number 14. If you have read section 133 of CPC, you will be knowing it. Its correct answer is the Chairman of Union Public Service Commission, right? So fourth is the correct answer. Yes, Ankita ji, 12th ka 3 is the correct answer. Next question, question number 50. Under Order 32, Rule 1 of CPC, a minor means a person who has not attained his majority within the meaning of option 1, Juvenile Justice Act. Option 2, Code of Civil Procedure. Option 3, Indian Majority Act. Option 4, Hindu Minority and Guardianship Act. What should be the correct answer? Question number 50. Yes. Under Order 32, Rule 1 of CPC, a person can be considered as minor who hasn't attained the age of majority. Okay? Under, within the meaning of which act? Juvenile Justice Act, Code of Civil Procedure, Indian Majority Act, and Hindu Minority and Guardianship Act. What should be the correct answer? Its correct answer will be your option 3, that is Indian Majority Act, right? Saksham ji, 13th ka 4th nahi, its correct answer will be option 2, right? Question number 15, I think it's clear. Let's move on. Question number 16. So this is the first question from the concept of ट्रांसफर ऑफ प्रॉपर्टी एक्ट, ठीक है, विच अमंग द फॉलोइंग इज फॉल्स अबाउट द टर्म क्लॉग ऑन रिडम्पशन. 14th का सक्षम जी saying 1 is the correct answer. No, 14th का सक्षम जी 4th is the correct answer. Yes. Which among the following is false statement about the term clog on redemption? Option 1, it is an absolute right. Option 2, it is a statutory right. Option 3, it can be fettered by any condition. Option 4, any condition contained in mortgage deed which obstruct the right of redemption will be null and void. Question number 16, what should be the correct answer? So they are asking the false statement. Firstly, so we have to understand this, that they are asking a false statement, right? So which of the following statement is false? It can be fettered by any condition. No, clog on redemption cannot be fettered in any condition, because clog on redemption is providing the absolute right to the mortgager. So in any condition in the mortgage deed which obstruct the right of redemption, that particular condition will be null and void, right? So its correct answer should be your option 3. Right, next question, question number 17. What is the effect of holding over? The lease becomes illegal, the lease becomes renewed, the lease becomes extinguished, and option 4, the lease becomes void. Effect of holding over under section 116 of Transfer of Property Act. What is the effect of holding over? The lease becomes illegal, renewed, extinguished, and void. So the effect of holding over is that the lease is renewed. So 2 is the correct answer for 17. 16 ka Saksham ji 3 is the correct answer. Question number 15, yes, 3 is the correct answer. Both of you are correct, Saksham and Ankita. But Saksham ji, question number 16, 3 is the correct answer. Try to follow this concept of clog on redemption closely. It is important from your mains perspective as well. Next question, which of the following do not convey the title? Which of the following do not convey the title? Question number 18. So first, registered exchange deed. Option 2, registered will. Option 3, registered gift deed. Option 4, registered sale deed. Question number 18. Which of the following do not convey the title? तो किससे title immediately convey नहीं होता है, right? Yes, 16 का 3 is the correct answer. Saksham ji and Ankita ji, both of you are correct. Question number 18. So registered will do not convey the title immediately, right? But in all other cases like exchange deed, gift deed, sale deed, these deeds convey the title immediately. But registered will convey the title only after the death of that particular person who prepared the will. Okay? So its correct answer, 18 ka correct answer should be your option 2. Question number 19. Within the meaning of section 51 of Transfer of Property Act, the transferee, option 1, is not entitled to the value of improvements. Option 2, is entitled to the value of improvement. Option 3, has conditional entitlement of value of improvement. Option 4, none of these or none of the above. Question number 17, yes, Saksham ji, 2 is the correct answer. Question number 19, padhiye and just let me know what should be the correct answer. Option 1, that the transferee is not entitled to the value of improvement. Option 2, is entitled to the value of improvement. Option 3, has conditional entitlement of value of improvement. Option 4, none of these. So what should be the correct answer? Yes, As per section 51 of Transfer of Property Act, it is entitled, like the transferee is entitled to the value of improvement. So 19 ka 2 is the correct answer. Yes, Ankita ji, you are correct. Saksham ji, you are also correct. With in reference to question 18, no. Correct answer will be option 2. Next question, question number 20. Which section of Transfer of Property Act preserves the rule of Mohammedan law and exclusion the applicability of section 123 of Transfer of Property Act, ठीक है, which mandates that the gift of immovable property must be affected by a registered instrument as stated therein? Option 1 section 126, option 2 section 127, option 3 section 128, and option 4 that is section 129. So which section of Transfer of Property Act preserves the rule of Mohammedan law and excludes the applicability of section 123 of Transfer of Property Act, which mandates that the gift of immovable property must be effected by a registered instrument as stated therein? Option excuse me, option 1 section 126, option 2 section 127, option 3 section 120 excuse me, option 3 section 128, and option 4 section 129. 19 ka yes, Saksham ji, 2 is the correct answer. Question number 20, its correct answer will be your option 4, that is section 129. Next question, question number 21. Now this particular question is from your Indian Contract Act. Question number 21. Which of the following is not a quasi-contract? Right? Option 1. Obligation of the person enjoying benefit of non-gratuitous act. Option 2. Responsibility of finder of goods. Option 3. Quantum merit, and option 4. Novation. Right? 20 ka Saksham ji, 4 is the correct answer, not 1. Right? So 21, question number 21, its correct answer will be right. क्या होना चाहिए? Obligation of the persons enjoying benefit of non-gratuitous act, responsibility of finder of goods, quantum merit, and novation. So its correct answer should be your option 4, that is novation. Novation, alteration, rescission, these things are defined under your section 62 of Indian Contract Act, while the quasi-contracts are defined from section 68 to 72 of that is in chapter 5. Okay? So novation will be the correct answer, because they are asking which of the following is not a quasi-contract. Right? Next question. Question number 22. A contracts to sell and deliver 500 bales of cotton to B on a fixed day. A knows nothing of B's mode of conducting his business. A breaks his promise, and B, having no cotton, is obliged to close his mill. Is A responsible for loss caused to B by the closing of mill? Option 1, yes. Option 2, no. Option 3, to the extent of loss caused, and option 4, none of these. Right? A contracts to sell and deliver 500 bales of cotton to B on a fixed day. A knows nothing of B's mode of conducting his business. A breaks his promise, and B, having no cotton, is obliged to close his mill. Is A responsible for the loss caused by B by the closing of mill? Option 1, yes. Option 2, no. Option 3, to the extent of loss caused, and option 4, none of these or none of the above. 21 ka yes, Saksham ji, 4 is the correct answer. Question number 22. If you will read section 73, there is the illustration given over there, and this problem is based on the illustration of that question. So its correct answer will be 22 ka correct answer will be no, that A is not liable for any loss caused by B by the closing of his mill. Right? Next question, question number 23. X hires a carriage of Y. The carriage is unsafe though Y is not aware of it and X is injured. For the injury of X, Y is option 1 liable, option 2 not liable, option 3 liable to the extent of 50% and option 4 none of these or none of the above. X hires a carriage of Y. The carriage is unsafe though Y is not aware of it and X is injured. For the injury of X, Y is option 1 liable, option 2 not liable, option 3 liable to the extent of 50% and option 4 none of these. So what should be the correct answer? Its correct answer is Y is going to be held liable. So its correct answer 23 ka correct answer is option 1, right? Question number 24. A enters into a contract with B to sell him 100 bales of cotton and afterward discovers that B was acting as agent for C. For the price of cotton, A may sue. Option 1 only. 22 section is saying no. Okay, so you are answering it as no. Okay. Question number 24. A enters into a contract with B to sell him 100 bales of cottons and afterwards discovers that B was acting as an agent for C. For the price of cotton, A may sue. Option 1 only against C, option 2 only against B, option 3 against both B and C, against B or C or both, right? Option 4 neither against B nor against C. Question number 22, yes, both of you are correct, Saksham and Ankita. Question number 21 के रेफरेंस में भी both of you are correct, Saksham and Ankita. Question number 24, its correct answer should be your option. Question number 24, its correct answer should be your option 3, right? That is against either B or C or both of them, right? Question number 23 ka no Saksham ji, it will not be 3, it will be option 1, right? Question number 25. Under Indian Contract Act, goods displaced in a shop with a price label, ठीक है, प्राइस होना चाहिए था, यहाँ पे प्राइस लिखा हुआ है, प्राइस PRICE, प्राइस लेबल will amount to option 1 offer, option 2 acceptance, option 3 an invitation to offer and option 4 counter offer. So I think this particular question, yes Ankita Gupta ji, 23 ka 1 is the correct answer. Question number 25, this is like quite repeated question. If you are appearing for judicial exams, so this is the question which usually we follow at quite early stage. So its correct answer should be your option 3, that is an invitation to offer, right? Next is your question number 26, ठीक है, an injunction granted. Question number 24 का yes Saksham ji, 3 is the correct answer. Question number 23, Ankita ji is correct, 1 is the correct answer. Now, an injunction granted during the pendency of the suit under section 37 of Specific Relief Act is, an injunction granted during the pendency of the suit under section 37 of Specific Relief Act 1963 is. Now this is the first question from your SRA. Option 1 perpetual injunction, option 2 mandatory injunction, option 3 temporary injunction, option 4 permanent injunction. Perpetual, mandatory, temporary, permanent. Question number 26, what should be the correct answer? Yes, बताइए. Question number 25 का Saksham ji 2 नहीं 3 is the correct answer, that is it is an invitation to offer. 24 का Ankita ji 1 is the correct answer, right? Question number 26, its correct answer will be option 3, that is temporary injunction, right? That will be temporary injunction. Right? Question number 26. Next is your question number 27. Under Specific Relief Act, when injunction can be granted? Option 1. Under Specific Relief Act, when injunction can be granted? Option 1. To prevent the breach of contract, the performance of which would be specifically enforceable. Option 2. To breach on the ground of nuisance, an act which is not reasonably clear that it would be a nuisance. Option 3. To prevent a continuing breach in which the plaintiff has acquiesced. Option 4. When the plaintiff has no personal interest in the matter. Question number 27. What should be the correct answer? Now, to prevent the breach of contract, the performance of which would specifically be enforceable. Option 2. To prevent on the ground of nuisance, an act which is not reasonably clear that it will be nuisance. Option 3. To prevent a continuing breach in which the plaintiff has acquiesced. Option 4. When the plaintiff has no personal interest in the matter. Yes, Saksham ji, 25 ka 3 is the correct answer. Now, 25 ka Saksham ji is saying 4. Okay. No, it will not be 4, it will be 3. Question number 27, its correct answer is your option 1. Right? Sorry. Question number 27. Nahi ji, its correct answer should be 3. It's given wrong in the answer key. Its correct answer should be 3. Right? To prevent the continuing breach in which the plaintiff has acquiescence. Next question. Question number 28. As per section 40 of Specific Relief Act, where an instrument is evidence of different right or different obligation, the court may in a proper case, option 1, cancel it in part and allow it to stand for the residue. Option 2, cancel it in whole. Option 3, cannot cancel any part. Option 4, none of these. Question number 26 ka Ankita ji, 3 is the correct answer, that is temporary injunction, right? So as per section 40 of Specific Relief Act, where an instrument is evidence of different rights or different obligations, the court may in a proper case, option 1, cancel it in part and allow it to stand for the residue. Option 2, cancel it in whole. Option 3, cannot cancel any part. Option 4, none of these or none of the above. Question number 28. So this is like directly related with section 40, okay, which is stating that where an instrument is evidence of different rights and different obligation, the court may in a proper case cancel it in part and allow it to stand for residue. So its correct answer should be your option 1 or option A. Next question, question number 29. The grant of decree of specific performance for the court is option 1, discretionary, option 2, mandatory, option 3, arbitrary, option 4, obligatory. The grant of decree of specific performance for the court is discretionary, mandatory, arbitrary and obligatory. What should be the correct answer? Question number 29. If you will read section 20 of Specific Relief Act, you will come to know that the grant of decree for the specific performance for the court is, it is discretionary. It is not mandatory or arbitrary or obligatory. So 29 ka 1 will be the correct answer, right? Chali. Next question, question number 30. Under Limitation Act, which of the following shall not be counted for computation of period of limitation? Under Limitation Act, which of the following shall not be counted for computation of period of limitation? Option 1, the day from which the period is to be counted. Option 2, the time taken by advocate to prepare memorandum of appeal. Option 3, the time taken to obtain copy of judgment order award. Option 4, time taken for obtaining leave to sue as an indigent person. So what should be the correct answer? Question number 30. Under Limitation Act, which of the following shall not be counted for computation of period of limitation? Option 1, the day from which the period is to be counted. Question number 26. Yes, Sakshamji, you are correct. 3 is the correct answer. Right? Now, under Limitation Act, which of the following shall not be counted for computation of period of limitation? Option 1, the day from which the period is to be counted. Option 2, the time taken by the advocate to prepare memorandum of appeal. Option 3, time taken to obtain copy of judgment order or award. Option 4, time taken for obtaining leave to sue as an indigent person. What should be the correct answer? Question number 30. Yes. Remember that here they are asking shall not be counted. Shall not be counted. So its correct answer should be your option 2, because rest of the times can be excluded, right? But option 2 cannot be excluded. Now, if you people have attended the video till now and if you found it informative for you, don't forget to like the video and don't forget to subscribe to the channel. Like, this is something which is quite obvious. Like, if you are attending the session till now and if you found it informative for you, only if you found it informative for you, don't forget to like it and don't forget to check out MP Civil Judge Prelims crash course. The link is in the description box. That might help you a lot, right? So